Board special call meeting, July the 11th, 2023, at 2:07 p.m. We're hereby called to order. Special call meeting, so basically whatever, only those items appearing on the agenda. So item number 2, certificate of appropriateness. Joni, if you'd like to bring us up to speed on the 126.
Yes, sir. In front of you, you have the COA. In addition, you have the letter from the county building inspector or city building inspector, and you have my full report on that. I suspect that we do have folks here that would like to speak on behalf of that particular hearing, and I also have our attorney for this, Henry Smith, is also here and will be helping us through this. So
Welcome, Mr. Smith.
I'm happy to get started. I'm guessing there are people who want to speak. So call them up, sir.
On this matter, are there folks in the audience that would like to speak? Somebody raise their hand and we'll.
Do I speak?
Mr. Montgomery, if you'd like to speak, please approach the lectern. Introduce yourself.
I'm Tim Montgomery. I'm the owner of the property at 126 South 4th Street, and I'm requesting two things. There are a set of steps that start on another piece of property and they end on my property. We wrote a letter to the other owner and they suggested that we ask you guys about the steps, so I'm there for that reason. Also want to build a fence on the property line, or 6 inches. I think the details are in the package. Okay. And the composition of the fence is in the package as well.
Any questions?
Any questions?
How long has those steps been there, Tim? Do you know?
They were, I can't remember where they were before. They moved them, and if you go look at the property,
I have.
They go down. Did you see the Kentucky Utilities meter?
Yep.
They were put there sometime after that. Those set of steps, I would think were put there 8 years ago. But I don't remember the configuration. I think they came down and turned, another direction at one point.
I've got one other question. It's going to be to both of y'all. Were those steps there when you bought it?
Yes.
Okay, so you're basically, number 1 is your steps, number 2, you're asking for a lot, for the fence?
To build a fence.
For the fence, okay.
Okay.
Very good. Any other questions from board members?
No.
Thank you, sir.
I would like to make sure you understand the steps aren't safe. You can only go 12 feet without having a landing. Then you have to have 36 inches at the clear bottom part of it for a landing. There's a gas meter on my property. If someone's carrying a suitcase down those steps and trips, they're going to end up on my property, and it needs to be corrected.
Does that make you potential liable?
Very much.
Okay.
Thank you, sir.
Okay.
You want to help put,
Mr. Tyson, okay if I come up and speak?
Mr. Dean? Yes, sir. Good to see you.
Good to see you all. I'm going to go ahead and give you all some color copies. It's Haddon Dean, H-A-D-D-E-N.
You ever heard of Dean's Milk? There he is.
Unfortunately, I'm not part of that conglomerate, but I will say that my grandmother, Georgia Dean, was a Sanders, and she had Colonel Sanders at some of our family reunions, but when he passed, I got none of the inheritance from that, so.
You sure don't look like it.
So my claim to fame is closer to Kentucky Fried Chicken than it is Dean's Milk.
Looks like you got a lot from the dress.
So basically, I appreciate your all service on this board. I know you're not paid. The scope of this board is very important. My great friend and dearly departed mentor, Ed Hayes, was part of the making of this back a year before I took the bar exam. So I can understand the importance of it. We have filed a brief response. Mr. Bowling's questions, I think, are very intuitive. We believe that these set of steps have been there for years, if not more than a decade. The images that I presented to you show part of the complications that arise with deleting 2 of these steps. Mr. Irwin and I have exchanged some correspondence on this. We have gone ahead, Mr. Pennington and I have filed a lawsuit for a quiet title and to try to address these legal issues in front of Judge Dotson in Boyle Circuit Court. So that has been initiated shortly around the time frame this petition was filed. We would ask this board to refrain from issuing a ruling on these 2 specific issues. One, is a little bit premature, candidly. Second, because there are questions, and we have attached a copy of the suit we filed that demonstrates that we believe that Centerview Properties owned by Ms. Hilp actually does have a vested title interest in this property. To the extent that there are or are not chip hazards or whatever, those can be addressed at a later date. Absolutely, I assume everybody's got insurance. But the problem with removing the steps is that clearly creates a hazard for anybody trying to go up and down the steps. And the important part of those pictures is that if you look, there is a utility shed that goes down subterranean that will not allow you to make those 2 steps turn in a simple fix. It's a much more complex situation than that. But due to that, we think that this board would simply table this until there's an opinion from the Boyle Circuit Court. That would be great. I think it would be more appropriate for Mr. Montgomery and my client before a lot of other resources are expended, other disputes arise, that we get a ruling from Judge Dotson. Candidly, I believe because the issues are very narrow, I think that this can be expedited in front of Judge Dotson. As I was preparing for today, I saw there's actually some other courts, and actually Mr. Irwin serve on his local rule committee. And there are several courts now that have developed kind of for lack of a better term, a rocket docket. And property issues like this are typically contained in that. I'll be talking to Mr. Irwin about facilitating that because I don't want Ms. Hilp or Mr. Montgomery to have to labor for months and months or years to get a decision. I think this can be decided relatively quickly. But one thing I don't want there to be a false impression on is the plan and the design does not give authority to subsume the issues we presented to Judge Dotson. And again, I don't want to reflect negatively on the scope of the jurisdiction of this board, but you've got competent counsel, and I think he'll understand our arguments there. We want, we want to be fairly heard in front of Judge Dotson. Once that ruling comes down, it'll be very apparent which side of the fence, pun intended, we will fall on there. But I have a great respect, understanding for what Mr. Montgomery wants. I also have a great respect and understanding of what Ms. Hilp wants. We do believe there are diverging factual issues that must be decided by Judge Dotson on, again, you've got a copy of the actual complaint that's been filed. There's quite a bit of law that supports, I think, the Centerview position, and Judge Dotson may or may not agree with us. Whatever his ruling is, we will certainly stand behind that, subject to either Mr. Montgomery or Centerview's right to appeal. But at this point, we believe it'd be premature for the board to issue an opinion on this. I have reviewed the rules of the board, and I've talked. Joni's been great. Whatever you do, make sure you pay her a lot because she's so responsive and so helpful. But with that said, you all know the rules and the bounds you have. You have so many days after the hearing today to make a decision. If you don't make a decision, by default, you've made a decision to grant the application. We would just ask in candor that you go ahead and give us some guidance on what you want to do. We would ask the board to refrain on issuing a ruling now. It doesn't preclude you later from doing this. This is not a situation under the law that it's double jeopardy or res judicata. If you decide against this now or you defer it now, doesn't mean Mr. Montgomery can't come back later if he has a favorable ruling from Judge Dotson. So I think as that decision is made, you can address both of these folks' concerns in a very fair and more informed manner once that opinion comes out. So that's really all I have to say on behalf of Ms. Hilp and her business, and with candor to Mr. Montgomery. That's what we would like to have happen, and I know both parties want to get this done as quickly as possible. Any questions that you have for me?
Same question I got asked Tim. Did you know this situation when you bought it? You didn't?
I don't believe Ms. Hilp understood that she couldn't use the property. She had used the property in this manner the whole time. Actually,
That's not my question. My question is, were the steps were there when you bought it?
Yes. Yes.
So were you aware that the steps were on somebody else's property? The lawyer didn't tell you that? So when you bought it from the real estate agent, they didn't share with you that those steps run down on somebody else's property? I guess the same question to you as I asked for Tim, you know, how long have they been there? And what's the law? What's the law say?
well, if you look, there should
No,
be
I
an
don't want
attached.
to look, I want you to tell me.
No, that's a great question. There's two basic issues. One is just a quiet title. We believe there's an adverse possession interest there because that's open and obvious. It's been there for more than 15 years. It's been used that manner. Mr. Montgomery actually owned property next to that before he bought this particular tract, if you'll think about it as a long rectangle where this building is that he owns. Actually, it is only the brick in the back, the brick in the front, and the ceiling, because the walls belong to Centerview, and the wall east or south of his building is actually owned by another property. So all of that has existed for years, and we believe that the facts will support that from an adverse possession claim. Alternatively, the quasi-easement issue that's in the complaint outlines a list of factors that we have a burden to prove. But when you go back through and look at the elements of that claim, when you look at the consistent use by a mutual owner, because if you go back in each of their respective chains of title, those will merge into Ed Hayes. Ed Hayes owned them both, and then after that, though, the title to the property Mr. Montgomery owns and wants to improve, and the property now Ms. Hilp owns were owned by Ed. But that common ownership created this use that's being displayed in the photographs I've presented to you. That consistent use of that property when it's open and obvious, if you got a title exam, it would say it's open. The title is subject to anything that you see upon visual inspection. We believe the visual inspection will have always presented these steps were used for that purpose. If these steps are removed, then the access to the second floor is no longer for Ms. Hilp and her business. There are some rental units up there that are consistently being used. The shed that you see there can't just easily be moved. It's access to her electrical and plumbing infrastructure under the building. So when you look at the reasons why it's structured the way it is, we believe that there's at a minimum an easement there if she doesn't have a title interest in the access to that parking lot.
Excuse me for interrupting, is there any place on the books where there is an easement there?
I'm sorry?
Is there any place that you found out that there is an easement there?
Well, hence why if you read the face of the complaint, it's an implied easement. When you buy a property, you're subject to the easements that you would see when you make a visual inspection. These steps have been there, we believe, well longer than 15 years.
I think I know the definition. What's your definition of adverse possession?
So there are 5 elements to that. So you have to meet all 5 of those elements. The critical ones in this case, and in every case really, has been there for longer than 15 years. We believe the testimony will be that it is. And it's got to be open. Clearly these are. It's got to be obvious. Clearly these are. And it's got to be used for her purpose. And it would be hostile to the interest of the other party. The steps where they're at don't serve the property Mr. Montgomery owned at all. I agree. But it does serve the property that Ms. Hilp has owned, and it's been there for more than 15 years. So we believe that claim is one that has to be decided by a jury. It's a fact question. You don't get summary judgment on those unless we fail to meet one of the elements. We believe we've met those elements. But with candor to Mr. Montgomery, his counsel's not here. I know that he may have a different take on the facts, but that's what the lawsuit in Boyle Circle will do, is allow Mr. Montgomery and Bill Irwin time to present their arguments on those issues, us to take depositions on those, and then come to some consensus on whether there is either one, a settlement, which I don't know there could be, maybe there would be, or secondarily is what issues need to be presented to a finder of fact, either a jury or directly to Judge Dotson. The jury piece, candidly, will probably take a little bit longer. I'll have to talk to Ms. Hilp and Mr. Irwin about, if we want to consider presenting it to Mr. Dotson's bench for a decision. That could be a 2 or 3 month delay one way or the other once the discovery is done. But there are legitimate legal issues that we believe support the conclusion of the use that Centerview has had to the property. I fully understand But candidly, with all due respect, don't agree with the position of Mr. Montgomery or Mr. Irwin. But that's the nature of why we have courts. Has worked this way. You know, our system works well. I know a lot of people bash it, but this is a prototypical example of two people with different views on something that needs to be settled by a court. And to that end, once that's resolved, your job will be easy. Now, respectfully, it's not, because the dispute exists. Any other questions? That's a great question, Mr.
I
Bowler.
don't, thank you, I don't have any other.
Great explanation, thank you.
Okay, thank you, Mr.
Thank
Ty.
you.
Mr. Dean, have you seen the staff report and staff recommendations for this?
I have not.
Okay.
I'm gonna make a-
We'll pass those to you and let you get a look.
Okay.
I haven't seen them either, should I?
Yes, absolutely. I've made plenty copies.
Hi, I'm Henry Smith. I'm counsel for the board today.
Election. Mr. Chairman,
Hold that just a second. Is it within the purview of this committee to do a contingent approval? Is that part of what we're documented there, Mr. Smith?
That is the nature of one of the staff recommendations, to approve the design of the wall contingent upon a supportive
court.
order from the court, or to deny it based on other factors. Those are, I think, the two options before the board today. I agree with Mr. Dean that there are issues that need to be decided by the courts. I'm also sensitive to the fact that this board has to make a decision within 45 days of receiving the application.
Joni, is the criteria for the construction of the wall / fence, is that in a perfect world without this?
Well, let us go through this a step at a time.
Do that.
The first thing that comes before us is the removal of those two stairs at the very bottom of that staircase that's attached to that building. I went over and looked at that. I did not see an additional egress from that second floor, and at that point, I called the State Fire Marshal and the Bull County Building Inspector, because that's not my bailiwick, and I wanted to make sure
Okay.
I was correct. You will find attached with your packet a letter from William R. Cox, the Bull County Building Inspector, that he wrote on the 15th of June, stating that that is the only egress from those two Airbnbs on that second floor. Given our guidelines, Section 4, Universal Guidelines 4.4.2, Accessibility and Safety, the very first guideline says, review applicable accessibility and life safety codes to determine if proposed changes are compatible. The Bull County Fire Inspector kind of came down on the side that that is an egress. So I've referred to the attorney on that, and we'll go over that in a minute. The second is the guidelines for walls and fences. There are, attached to that with findings of facts, there are walls that are very similar to that in the same parking complex. I think Central Kentucky Federal Credit Union has one that I have pictured there that's the brick pilasters. So the way the wall is constructed, the materials it would be constructed at are appropriate for the district. There's no problem with that. It comes down to the placement of the wall. And given that's an issue apparently with the fire marshal as well. So I talked with Henry about this a great deal. He has set before you two staff recommendations, and you can see very well what they are. And then I would have to defer to him and you to make that decision.
Okay,
But as far as the wall goes, the design is appropriate for the district.
okay, very good, thank you. Mr. Bowling?
I'd like to make a motion to approve the wall and design only and hold the certificate of appropriateness pending on the resolution from Bull Circuit Court. And that lets the court.
And I'd like to second that.
So I have a motion, I have a second. Any further discussion on those?
Call for the question.
All in favor?
Aye.
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 Any opposed? None opposed.
There you are.
That was staff recommendation, so.
Mr. Bowling, could you repeat that again? Was that basically just to approve the wall design only, subject
to approve the wall and design only,
Okay. Subject to.
and hold the certificate of appropriateness pending the resolution from the court.
Yeah, that is your first staff recommendation there.
Yeah.
That's what I thought I heard,
Okay.
and I'm sorry, I was trying to scribble something down.
That's okay.
I can't write that fast, so thank you.
All right. Now, item number 2. Thank you, folks.
I got a follow-up question.
Just can't let it go.
No, I just want to make sure that everything is, have you all talked, you and Tim talked about this? Have y'all, wait a minute, let me read, without the lawyers, have y'all talked with each other without the lawyers? No offense.
No offense taken. There was a little discussion, and then Bill and I got involved, and
I guess I was looking at some kind of resolution before it went to court. Sometimes,
It's interesting
sometimes
that-
talking gets a lot done.
When they talk about the steps, because there's ample room to come down those steps, stop, put a 36-inch landing, and come out into her parking lot and do the steps safely. That's easily done on her property. If she come down my steps and make those steps, she has to go another 3 feet onto my property, and then an additional 36-inch landing on my property. It's not practical to have it there. This property was for sale. It was offered to her. She turned it down. She knew the steps were there. She even painted part of the neighbor's building.
Beyond the purview of this meeting. Thank
There you
John,
go.
For your question.
Yes.
Counselor,
that's all I have. I can be excused if you all have any
You may
other
be
questions.
excused.
I'll have to try to answer them. We, again, really appreciate your time and the foresight and council's work on this. It's-
good seeing you. Haven't seen you in forever.
I know. It's good to see you. You haven't aged, I have. I'm catching.
Tom, question.
Yes.
Aesthetically, I would suggest that what Mr. Montgomery said would yield a much more attractive look in the back of that building.
She's our
That's
resident
just an
artist on the
opinion.
board. It's like, what looks pretty?
This looks pretty makeshift and Rube Goldberg kind of,
Okay.
not thought out real well kind of solution.
It's a comment. and
It's
in
an
there. Okay.
opportunity to fix that.
Thank you,
There are a lot
folks.
of thoughts on how to beautify that back there. One proposal she had early on is repave the whole thing, put marks down, so everybody knows where the spaces are. The dispute about the spaces is what brought us here, candidly, is the restaurant is using that area to access to bring in their food services and products rather than clog 4th Street. And putting the wall there would make it impossible, but she has her primary business for AAA there. There are parking spots there where she comes in and parks perpendicular to the building that will not be allowed at all if the wall goes in. She'll have one parking spot in essence and 0 access. So that would necessitate then the restaurant to have, soon to be, one of the only lanes going through there, congested more by food delivery trucks, things like that. So that's part where, good
Well,
people disagree on the facts, and that's where we're gonna get.
I hope it works out for the good of both of them.
Yeah,
That would be-
yeah.
Mm-hmm.
But we look forward to working with Judge Dodson, and trust me, Bill, when I was telling, this is my intern who's getting ready to take her first step in the law school classroom in August.
Is it,
So
is it,
hopefully
is
she's
it,
learned
is
a
it
little
true?
bit of what not to do, maybe. Bill and I got sworn in together in October of 1994. He was 2 people over me. I'd never met Bill ever in my life. And he started talking about going back and practicing in Danville. I said, well, I'm going to be in Harrisburg. But he went to Northern to Chase Law School. I went to U of L. But we met our first day, October 14th of 1994.
Is a rumor true, am I on the record?
You're being recorded. Yes, you are.
On a light note, is it true that what the rumor is on Main Street? That you can walk on water?
Well, we've had some, yeah, well, I'm learning better. I'm not good at it yet, but
Good to see you. Good to see you both.
Thank you, sir.
Thank you for your time. Appreciate you.
Yes, sir.
Thank you all.
Well,
Okay, item number 3, moving right along.
All right, Mr. Chairman, you have in front of you the administrative approval for some signs at 116 East Main Street. These were already installed. I was talked to the owner. Let me find it. Basically, they changed the fascia sign of one that was approved by this board some years ago. And they have added in, as you can see, that small sign. That is a standalone pole-mounted sign, which is appropriate for the district. However, I've sent that over to planning and zoning, as I'm not sure that the placement is in the appropriate area. But as far as the design of the sign, that's fine by us. We're good with that. So those were approved, and that COA has been sent to them. And planning and zoning has also got an email from me talking about the placement of the pole sign.
How long have these signs been there?
Well, the sign has well exceeded the 30-day, the standalone sign has well exceeded the 30-day of being a temporary sign. So it should now be considered a permanent fixture. And it's been there for some time. I can't tell you exactly how long, but for some time.
Any questions?
Well, yes. Aren't there 3 signs there? You've got the wall sign, the pole sign, and you've got a sign out in the
Yeah,
right-of-way.
there's a blade sign. Is that correct?
That's what you're calling a blade sign?
Yes, sir. That was approved a few years ago.
So that's the picture that you have in this,
What you have, the 2 pictures that you have are of the sign attached to the building,
yes?
and then the pole sign that's out in the curb, that's on the curb.
Oh, okay, you're calling it.
I wasn't, there's another sign that's a blade sign that's attached to the building in front of the, I guess, Mr. Dexter's real estate agency that he had applied for some years ago and was approved.
Okay, so that's not a part.
Not a part of this one. No,
Okay,
sir.
I understand.
Any other questions? All righty, that's been approved and sent through.
Okay.
Let me ask you a question, Mr. Attorney. What happens one way or the other? What if the judge rules in favor of Mr. Montgomery? Then the appeals process kicks in. Where does it go from there?
If they rule in favor of Mr. Montgomery, then your order grants the certificate of appropriateness. If there is an appeal, then, attorneys can seek an injunction against issuance of that certificate of appropriateness at that time.
I see. Okay.
Right.
So I guess my question is, where would it stop? Eventually, somebody has to make a decision and it goes no further. Does that?
Right. Either resolution outside of court or it stops at the Supreme Court.
Okay. Good deal. Wow.
But I also note that the certificates have a duration of 1 year. I guess it's not been issued yet, so that's, yeah.
Yeah.
Wow. Thank you for
Okay.
what you do.
Thank you, sir. Joni, update on realignment of staff?
Well,
Is that me or you or?
well, you can go ahead and give a brief. We have the attorney here for planning and zoning.
Your description's probably going to be better than mine. I mean, we're kind of up in the air. It's my best
Well,
description.
It is my understanding that Earl has directed Stephen Dexter and Mr. Smith to come up with a couple of options on how to pull the architectural review board under the purview of planning and zoning. That's what I took from the meeting. Is that correct?
That's, purview might be a strong word, but it's not being controlled by
Under the
planning.
umbrella,
Under the umbrella.
I would say.
We'd still do what we do. It's just our budgeting and
Right.
everything
The
runs
concerns
through.
I had were the funding, certainly, how the funding mechanisms were going to work. I don't think that's been worked out just yet.
No, though there have been assurances that it won't be diminished.
Right. I suspect they're going to do a standalone budget under planning and zoning because the city will have And then
And-
it's, you know, at that point, I don't foresee anything changing at all other than I will be punching a time clock for planning and zoning as opposed to the city of Danville.
Part of the thinking on that, and we've discussed this, you encountered this back in your days as mayor. So a developer comes to town, I gotta talk to planning and zoning. Well, they send him down the hall to talk to DAHB. No, you gotta go back to planning and zoning. Well, it's a lot easier if you go to one desk.
I agree.
And that's some of Earl's thoughts, is we serve a lot of the same functions. Not entire, our mission is not the same, but it's a lot of the same functions.
Well,
It just
I
don't
would,
make
I would be in
sense.
favor of that as long as it doesn't jeopardize what you've already done and what this committee, before I got on here, had already done. I mean, I would hate
Well,
to
there's
see.
certain legal requirements from the CLG, City Certified Local Governments, that we have to have, you know, someone with her credentials, et cetera, et cetera. So that,
Well, I don't, I'm gonna just be candid with you. What bothers me, if it goes under planning and zoning and you fall underneath their rule, then who's your boss down there? And then if you have a disagreement, I mean, I don't like that at all. I think you need to be totally independent as an employee of P and Z,
getting
in
that
my
down,
opinion.
Mr. Smith? You getting that down? Getting that opinion? And
My opinion's not worth much, but I'm gonna give it. I can foresee issues down the road. You know, anytime you got human beings involved like that, then,
And Gary, you may have seen this in other parts of the world, so feel free to jump in here with,
Well, I'm very being on the other side of the counter for a long, long time. Having one-stop shop to get something accomplished for the developer or the owner is very appealing. So that's one side of me. But when you have cross allegiances between planning and zoning, that's the county, and you have the city that is more interested in, is equally as interested in historical preservation, you know, I think there's going to be some conflicts down the road.
it has to be.
Perhaps not, you know, perhaps can't be avoided, but it's going to happen.
if somehow it's built into that, you know, that she isn't having to serve two masters, which is an impossibility, then, you know, it's, or we're having to serve two.
Well, I would say this, whomever sits in this position is the staff for the Architectural Review Board, which is you. That's what this is built into. I think some of the discussion I was hearing from the meeting, that there may be some interest in the county as well to spread the historic preservation program and make that accessible for the county as well. I think, John, you and I have talked about Perryville. And that's in no way saying that this is in the plan or the works or make sure
Way out
everyone
there in the
understands.
clouds
This
somewhere.
was just a discussion. No one's wanting to put a H1 overlay on anything in Boyle County. So let me make that
You
very,
can-
very
you-
clear.
You can already see the
Well,
the
I
battle
mean,
lines.
There would be people that would be very much for it, and there will be people that be very much against it. However, I don't foresee this job changing because of the boundary of certified local government is within the city of Danville. You are bounded, as I am bounded, by that boundary. That is a H1 overlay boundary within the city. Once planning and zoning in the city of Danville have to deal with each other with that boundary regardless, because it is within the city of Danville. Now, if we had a historic overlay district in Junction City and another one in Perryville, I could start to see where there might be some conflicts. But as it sits right now, that has not yet occurred. And there is absolutely no plans for that to occur. Let me make that perfectly clear.
For whoever's listening.
My phone will ring tonight, I can assure you. So,
But Joni, you said,
I know, and I'm saying, again, there are no plans for that. But it would also, it would also give the county some access to folks who might have a historic farm and want to know about historic tax credits. I would do that anyways if someone called me. I have never turned down giving anyone help or advice regardless of if they're in this county, the next county, 2 counties over. But it might be a program that the county could have access to as well. As my understanding, all of the funding for this position and this program would still come out of the city and be given to planning and zoning as a standalone budget or some sort of agreement that way.
Are there any other crossovers like that?
There are a couple, Woodford County being one.
Well, specifically between Danville and Boyle County.
That I cannot speak to.
Would our Board of Adjustments as a subset of the planning and zoning be similar?
It's kind of a creature of the planning commission. It's under the same umbrella as
Okay,
the planning
okay.
commission.
So, no.
I don't think so.
Okay.
I'm not aware of any if there
And
are.
to be clear, planning and zoning is not a county agency, but a kind of a separate thing from either the county or the city. It's a special purpose governmental entity, so
Oh,
And so-
really?
it exists on its own.
Just to make it more confusing.
That's the idea.
Kind of unique to Kentucky. We might need to brief
It's-
on
it-
a
yeah.
special
Kentucky has many unique.
I've got a lot to learn.
library boards, fire boards.
Right.
Just, I guess, from what I took, I felt that there was some assurances from Earl that they had no intention of interfering with the program, defunding the program. I did not get that sense at all. I just felt like he is trying to make this a more streamlined process. And again, as I told you, all of this was precipitated by Bridget leaving codes and ordinances because there was an actual code and ordinance department in the city, and I'm assuming that that's no longer going to be. They're reassigning all those different responsibilities.
I'll be honest,
to-
I went into our meeting somewhat skeptical and came out of it going, oh, okay, this makes
Okay.
sense.
I don't see any, as long as the money is there, and I do think that we have to have some agreements on how the money flows. If there's grant funding, that it needs to come back to the city, some of those things. But otherwise, I don't see any major issues with this.
Well, and I think it brings it back into alignment of things you and I have desired for a while. You know, when we have our meetings, we need the planning and zoning director here. We need counsel for most meetings. This has been a rare privilege. Thank you again, Mr. Smith.
My pleasure.
Most of the time, I've been known to call a halt to a meeting to ask for counsel,
Which is a wise thing.
because sometimes we're just kind of on our own,
Right.
most of the time. So I think that'd be probably a big benefit,
I would not disagree with you.
yes.
I suspect that within a couple weeks, we will have this hammered out as to how it's actually going to work. I know that Tom and I will have another meeting on the 26th with the attorneys who are supposed to, I guess you guys are going to come up with some sort of plan by the 21st. And then we'll have another meeting, and then we'll be able to follow up with you all. I don't see any upset or realignment or anything about anything that we do currently. I
You
don't
know,
see-
Dana brings up a good point. I never even thought of it during the discussion about the steps, the aesthetics back there. So I've been up there twice to look at it. It's a mess back there.
It is, but fundamentally for us, John, our overwhelming guidelines is that we can't really interfere with life safety issues. We cannot do that. And I felt very strong. Yeah, we cannot officially do it. And sure. It is a mess, but
But both parties wanted to try their case today, and it's like,
well, it is not,
We can't. You
right, I
can't
get it, but we are bound by our standards and guidelines.
I can't believe that you buy a piece of property and you don't know those little things like that. I mean, I do believe it. I'm
Yes.
sorry.
understanding, remembering that.
I have a daughter-in-law that's a real
I
estate
would never
agency.
do that.
She can enlighten you on some incredible horror stories, but
Really, I mean, there's not only 2 steps, there's a whole roof and poles and all.
it is,
Their property.
Remembering it went back to a common owner, and I'd forgotten that
Yeah.
once upon a time. I'm
but, and
like,
what we also need to
okay,
understand, it's
now I
not Ms.
understand how
It's
it
not Ms.
happened.
Hill filing
Well, you fix it.
anything, it's
Yeah,
Mr. Montgomery.
that's why there's no documented cross easements or anything.
Right.
Oh, that's cool.
Yeah.
Sure.
Sign the deed.
Well, we did our due diligence, and we cannot make any rulings for life safety.
King Solomon's move, we cut the baby in half.
Well, and you were within your purview of approving the design of it because it's perfectly acceptable. There's walls all over, parking structures everywhere in Danville like that. So, they're going to have to work out in civil court the stairs and the placement of the wall. And then I guess we'll see them again.
Let the
Perhaps.
judge be the bad guy.
Let the judge be the bad guy. So
Who is Erie Landmark Company?
Erie Landmark Company, they do work for the National Park Service. They're one of the
So
contractors.
this is not the National Park
No,
Service.
sir.
This is Erie Landmark Company.
Yes, the National Park, and what we're talking about is Mr. Bowling's house. He would like to have a NPS plaque on
So
there.
this
for
is not a
that.
scam number, is it?
No, sir, no. I absolutely
The
talked
city
to,
should pay for that.
it's a $500 bill. I
Yeah,
suspect he'll want a raise at some point. But that is a legitimate company that's a contractor that the NPS approves
get
for
a-
that.
Do I hear a motion to adjourn?
I so moved historic.
Motion to
Put on the front
adjourn.
of the house.
I'll second.
I
Second,
didn't know it. All right.
all in
Second.
favor? Adjourn.
Aye.
Thank you, sir.